the business of your firm, law firm, it's about intellectual property, which is, and tell me if I'm wrong, which is protecting any kind of idea that it can be from a poem to the invention or the patent of the vaccine COVID-19, right? Am I right?
Absolutely, yes. Intellectual property protects intangible assets that are the expression of ideas. So there's three main types of IP, for short, is what we call it. Number one is what we're going to be talking about today, are copyrights, which protects original works of art. Think of films, music, paintings. So the song lyrics, the melody, and the recorded performances of artists are protected under copyright law. Next, we have trademarks. So those protect brand names, logos, taglines. Think of Nike, Just Do It, the McDonald's arches, Sony. Those are all very well-known trademarks. And trademarks, they identify the source of a product or service and allow you to distinguish yourself from competitors. So they have a lot of value. And then finally, patents are a form of IP, and those protect novel and useful inventions. So in the music industry, if somebody were to invent a new instrument or a new part of an instrument, that could be protected under patent law.
Perfect. And how long does it take if I have an idea and I want to start the process, let's say, call a lawyer like you, how long does it take for me to get it patented and make sure that I'm protected? And also, let's say that I want to develop it at the same time, and I have to share my information and my knowledge, but at the same time, I want to be protected. Can you tell me how that works? Because
Sure. Yes. So the patent process varies according to the technology and how extensive the application is. First, we often do a patent search to make sure that this invention has not already been applied for, because in that case, it may bar you from obtaining a patent. And it can take a couple of years sometimes for it to issue as a patent, or it can be very quickly. In terms of sharing it and protecting that patent and that idea, when you go to, for example, investors or another company that you want to produce your invented product, it's critical that you have a non-disclosure or NDA agreement, that you go into that meeting protected ahead of time, where it prevents that party from taking your idea and patenting themselves or marketing it for a certain period of time.
Say it again. What is it called? That kind of.
It's called an NDA, or a non-disclosure agreement.
NDA.
So yes.
So basically, if I have an idea and I'm willing to, I think it's something that is brand new, never been released or patented or whatever. I can call a lawyer and ask for one of these agreements, and then be protected. You send that, let's say nowadays you send it by email, or in that company just replies or signs, and then you can go to the meeting. Is that it a simple reply? Does that protect you, or do you have to have like something went on my eye?
Yes, you definitely want them to execute, which is a legal term for sign the contract. You need a written contract where both you and the other party sign on the dotted line, and have clear terms that specify what they can and can't do with the information you disclose during the meeting. Usually, to be enforceable, the NDA has to be limited in scope and duration, meaning it can't be forever, or else it likely won't be enforceable, or the other party likely won't agree to it if it's too long in terms of the duration. So you have to think about what the other party is going to be willing to agree to. But yes, to answer your question, both parties should sign the agreement before the meeting.
De la Sagrada Bitácora de Rock, Radio and More.
Rock, Radio and More. Estación orgánica